It's time for Law in Our Life, and that means we have An Hyun-ju here in our studio. She is a lawyer practicing here in Gwangju, and she's also a guest on our show, and she's going to tell us all about the Korean legal system. Hello, Hyun-ju.
Hello.
How are you doing?
Great. Thank you. How are you doing?
I am fine. Another episode in my suit, and so I'm glad to class things up on these videos that we put up. Now, we're going to talk a little bit more about the Korean justice system, I guess. Right?
Yes.
And we were talking about that last week, about the relationship with the police and the prosecutors. And I guess now you're going to kind of explain how things work. Right?
Yes. Today I'd like to talk about how the criminal case develops from police to and go through prosecution and then how it turns out in the courtroom.
All right, let's watch this whole thing. It kind of reminds me of it. This sounds like an old TV show I used to watch called Law and Order.
Yep.
And so I liked that show like 25 years ago. So let's hear what this sounds like.
So, once the case is reported to the police by the victim or the witness, the police will investigate, right? They will call in witnesses or collect evidence such as CCTV videos installed near the location of incidents, or they may get forensic results of the cell phone of the victim and the suspect to see any relevant evidence.
Okay.
So, if the police conclude that they have sufficient evidence to decide a case, they may transfer the case to the prosecution if the police concludes that the case is suitable for indictment.
Right. And last week, you pointed out that is now a decision the police can make.
Yes, they can decide whether they will transfer the case to the prosecution or not. So if they decide not to refer the case to the prosecution, there is still a way to make changes by the victim.
How's that?
They can file a 이의 신청, which is an objective opinion, and ask the prosecutor to look into the case and order the police to reinvestigate the case.
Right. So it's basically asking for a second set of eyes to review the decision to not indict.
Right.
All right. Well, let's assume the prosecution wants to indict.
Yes. Then the prosecution will press charges against the suspect. And now the title of the suspect is now changed to 피고인, which is the accused, not the suspect any longer.
Oh, okay.
So if you call somebody 피의자, it's somebody who is in the process of investigation by the police or the prosecutor. But if the case is moved to the court, then he's like the name we call him is changed to accused.
Okay.
피고인.
That sounds serious.
Yep.
I don't want to be the pigoin.
No.
All right. And I guess that's like kind of that's not just accused by the victim. That's like accused by the state.
Yeah,
at that point,
right.
Okay.
While one's status is a suspect, a person has very limited access to the criminal investigative records which is at the hands of police and prosecution.
Okay.
As I said, there will be CCTV videos or the forensic result of cell phones, but it will be in the hands of police and the prosecution.
Right, and they can't get that.
Yes, suspect cannot access those.
Okay.
Once the case is transferred to the case, and the suspect, like now the accused, is notified with the notice that the prosecution is seeking indictment, now he can have access and make a copy of the accumulated evidence that police and prosecutor had collected.
Oh, okay.
So including like the interview of the victim and other records.
All right, and they're not allowed to hide any evidence, right? Like they have to give full access to the accused.
The prosecutor may have more, but the evidence the accused can access is like more a stack of evidence that the prosecution will submit to the court as evidence to support the case.
Oh, okay. So what if they have evidence that they don't submit to the court?
Which is in favor of the suspect.
Right. Can the suspect get that?
If they know, it says the prosecution shouldn't do it. But if that happens, he may ask to submit all those evidence.
Right. Okay. All right. There is a way for that.
Mhm.
I'm just remembering like a courtroom movie I watched.
Yeah.
Where there was like a big break because there was a box that said, do not show to the defense. And it had, the evidence that would free the suspects.
Yep.
All right. Let's keep going. Let's go to our court date. We're in front of the judge. Good morning, judge. What's going on?
The judge will first ask the accused to self-identify himself.
Mm-hmm.
So he may ask what's his name, what the date of birth, the address, things like that. And the prosecution will be asked to announce the criminal facts that the prosecution is seeking indictment.
Oh.
So he will stand up and say, this person is charged with larceny and rape, and this is what happened.
Okay.
The judge then asks whether the accused admit or deny the criminal facts.
Is that the same as entering a plea? That's a guilty, not guilty kind of thing?
It's more like whether he's admitting the fact itself.
Okay. Like these are real CCTV videos and stuff like that. Okay, fair enough.
He will only do that for the accounts that the prosecutor was stating.
Okay.
So it's not about, I admit all the CCTV. I don't admit the statement of the victim. It's more about, yes, I admit that I stole something.
Okay.
I admit that I raped her.
Right.
Things
Okay,
like
yeah,
that.
so that sounds like a plea.
Yeah. The prosecution will bring in the list of evidence and a stack of evidence itself.
Okay.
It will be in the table in front of the prosecutor. It will be the evidence that the accused and his or her lawyer might have had a chance to review before that court hearing date.
Right, of course.
So for that, the lawyer or the accused will go into the prosecutor's office and make an appointment to see and copy that stack of evidence.
Sure.
So he will make his own copy and will have it with him. Now, the accused will be asked to give opinion on the evidence, which means whether he or she object to admit such evidence as it's fabricated or it's not true, or he or she may agree to make the evidence admissible to the court.
All right.
Or they may agree to the admissibility but try to alleviate the probative power.
What is probative power?
Probative power is a bit different from being admissible. So let's say I might admit that the statement you made against me can be admissible as evidence. Your statement can be shown to the judge as evidence.
Okay.
But I may say, but it does not have probative power because you're a liar.
Oh, okay.
So it's an evidence, but it doesn't have that much power to prove or support the case.
Okay.
So, yeah.
All right, I think I understand.
Yeah.
Run us through an example.
Yep. For example, if the accused and the lawyer deny the evidentiary power of the statement made by the victim outside of the courtroom by refusing to agree on such evidence, yeah, we can do that. Then the prosecution will request the judge to allow him to bring in the victim to provide the evidentiary effect to such hearsay evidence.
Okay.
So in that case, as the victim's statement was made outside of the court, and then it's called hearsay evidence.
Yeah.
In principle, it cannot be admissible as evidence because it happened outside of the courtroom.
All right. But
we really want to, because to save that evidence, we need to give it effect.
Okay.
And so even though the accused do not agree to make it admissible, if the victim does appear as witness called in by the prosecutor, and if the following 4 requirements are met, it's considered admissible, even though the accused do not agree on its admissibility.
Tricky stuff. We've got 1 minute, so give us the summary of the big stuff here.
Then the victim can come in and testify that the statement was made during the investigative process.
Okay.
It was recording in accordance with the due process. The record itself accurately reflects what she said during the interview, and the interview was conducted under the circumstances to guarantee the credibility of the statement. And lastly, the lawyer of the accused had the opportunity to cross-examine the person inside in the court.
In front of the judge.
Yes, then that's admissible.
Okay, so it takes a long time to do all that.
Yes, because they have to invite all those people who made statement outside of the court if the accused denied to have those as evidence. So it may take months. So after that, the judge will wrap up the case and he will just have a set up the date for the sentencing.
Okay. Any exceptions to any of this that we should know?
If some of the evidence, as I said, the victim should be brought in, but for the sexual crime evidence, sexual crime victims, usually their statement is recorded.
Okay.
By
and then,
video.
So they don't have to come in again.
Yes.
And see their violator.
Yep.
All right, that's good to hear. And of course, this is being put up on the internet, right?
Yes. You can find this segment in video and my YouTube channel. You can find me by searching Korean Law 101 on YouTube.
It's very informative. Thank you so much, Hyunju.
Thank you for having me. It was very long.
I guess.